and that he's going to handle their issue, and if he can't, he's going to tell them, or he just takes their money and then goes, oh, sorry, I tried. With that being said, he has a 100% approval rating for anybody who's trying to qualify for VA aid and attendance, and also he can do for anybody who knows somebody who needs VA and Medicaid. This is your guy. So I really wanted him to come out and meet all of you and share his wealth of information and give you the tips of the trade as you make your transitions or as you're planning for a transition. So with no further ado, Michelangelo Mortellero.
Thank you, Tammy. Always appreciate working with Tammy. We've been working together for over 10 years in the Tampa markets. But my firm, while we're based in Tampa, does serve Hillsborough, Pasco, Pinellas, Manatee, and Sarasota. So we do work actively down here. If there's ever a time that you need to meet with myself or any of my staff members, or certainly if you retain our services, there's never a time that you need to drive up to Tampa. We would always bring our services down to Sarasota and to Manatee counties to meet with our clients here. So a little bit about myself. I've been an elder law attorney for over 12 years. In that time, we've had over 6,000 clients come through the office, mostly in the world of estate planning for seniors. We also do some probate, which we'll talk about. The gentleman that spoke earlier is absolutely right about probate avoidance. We'll talk about that a little bit. Also, 80% of my revenue these days comes from veterans benefits and Medicaid benefits. And down in this area, we typically only talk about Medicaid in the world of skilled nursing homes, where if any of you know anyone that's been in a skilled nursing home, it can be anywhere from $9,000 to $16,000 a month to be in a skilled nursing home. And while many people here are fortunate enough to have some money put away for the rainy day, there are times where we can legally and legitimately shelter additional income and assets and get you in a great nursing home or a family member and not have to pay that entire retail price. We'll talk a little bit about that. We're really going to focus on estate planning and maybe some veterans benefits for today. Now, estate planning all starts with what we call advance directives. An advance directive is not an individual document, but it is a group of documents intended to assist you in times of disability or incapacity. As you may know, in Florida, as well as every other state, if something happens to you and you lose capacity, whether through a memory care issue like a dementia-related illness, or something like a stroke, or even it could be a car accident with a brain injury, if you lose capacity, we can no longer allow you to sign new legal documents. So you are effectively stuck with whatever you have, if anything. And many people have nothing. So if you lose capacity and you have not already been proactive and appointed someone to make legal, financial, and medical decisions for you, we have to get the courts involved. That court involvement is known as a legal guardianship proceeding. Guardianships are messy, time-consuming, and avoidable if people take the right steps while they're still younger and healthier to hedge against that risk. Often guardianships can be $5,000 to $15,000 to set them up. You need to be represented by an attorney every year for the rest of your life with court appearances and accountings and legal fees that just go forever. So let's talk about how to avoid guardianships. The first document that we talk about is a durable power of attorney. If any of you have estate plans that have already been done, I guarantee you that is, or certainly should be, one of the documents in your binder. Well, let's talk about the quality of those documents, because depending on the type of attorney that you went to visit to have those documents drafted may very well determine, for our purposes, the quality of your documents. Before we get there, I'll share with you a quick scenario, which is the explanation between an estate planning attorney and an elder law attorney. All elder law attorneys are estate planning attorneys. Not all estate planning attorneys are elder law attorneys. So what's the difference? Well, generally speaking, an estate planning attorney is interested in what happens to your assets from the time of your death to the time your beneficiaries get their inheritance. How efficient, less expensive, less time-consuming can we make that point A to point B? That's really what they're focused on. When you die, do you want just a will? Do you want a trust? Do we have any special needs beneficiaries? Do we have any minors, children, grandchildren, great-grandchildren that we might want to structure our assets to them in a way that is the safest possible route? And that's fine. But for a lot of folks who find themselves in need of senior living, whether that's independent living, assisted living, memory care, and then the big one, skilled nursing facility, you can have the best estate plan in the world, but if you have spent down a good chunk of your assets, or for some folks, spent down all of your assets at $16,000 a month, then you could have the masterpiece of trust that your estate planner drafted for you. If you have less than $2,000 to your name when you die, kind of what's the point of having a great estate plan? So an elder law attorney is concerned about our clients from the day that we meet them to the day that they die. Because if we can help coordinate with your tax professionals, with your financial professionals, to spend the least amount out of pocket that is necessary on getting great senior care, then there's more likely you're going to have more left in the bucket at the time of your passing to have a meaningful distribution out to your beneficiaries. So let's talk about that power of attorney. The power of attorney are the keys to future asset protection strategies. And when I talk about asset protection strategies, I always go to the worst case scenario, that $16,000 a month nursing home. You may have millions of dollars in your estate. It's a great place to be. But even with the many clients that I have that are millionaires and multimillionaires, if they have a choice of spending $16,000 a month or spending $2,000 a month, every single one of them, they didn't get to be rich by making bad choices. They will all opt to pay the lower amount for the same product than the higher amount. My power of attorney is the keys that allows that to happen. A good elder law power of attorney in the state of Florida should be no less than 30 pages in length. Sounds like a lot, and it is. General estate planning powers of attorney can be anywhere from 5 to 11 pages in length. That extra, potentially 20 pages of stuff is all of the tools that an elder law attorney might need in the future to protect your assets and to make sure that you get the care that you need while spending the least amount necessary. Whether that's community-based and county-based programs, whether that is VA benefits for veterans and widows, or whether that is Medicaid for the nursing home. So if you have a document that is less than 30 pages in length, I highly recommend that you have it reviewed by a qualified elder law attorney. Get an opinion on it. My guess is it's not going to have the language that you need. Certainly the folks that make more higher level of retirement income, as well as the folks that have a lot of money in retirement accounts and investment accounts, those are the people that need the extra language. So very important that you have that reviewed. What does a power of attorney do? Simply put, it allows you to appoint someone to make legal and financial decisions for you if you lose capacity to make your own decisions. Many husbands and wives get lulled into a false sense of security. I'm on the house, we're both on the house, we're both on the checking account, we're each other's beneficiaries for our life insurance and retirement accounts, so who cares? Well, here's how it might matter. Great senior living places like this, people want to move into, and Tammy keeps the funnel moving of great people moving into this community. Well, if you and your husband move out of your house, husband has dementia, he's getting memory care, you're in independent or assisted living, or maybe you need memory care too. Well, once someone loses capacity, they can't sign up with the realtor to sell the house. So even for husbands and wives that have everything jointly owned, crucially important that they have power of attorney for each other. And so if we need to sell the house, you can go to the realtor, sign all the documents, go to the closing table, sign everything, and then if necessary, protect that money for future benefits. So power of attorney is crucial. The law in Florida changed October of 2011. So that's another note. If your documents are older than 2011, technically they are grandfathered in, but I highly recommend a review by a qualified attorney. If they're from out of state, a lot of people transplanting into Florida for retirement because they get sick and tired of shoveling snow, and I don't blame them. Every state has reciprocity with every other state, so the documents in theory are still good from wherever you used to live, but they certainly do not have Florida language in them. Without Florida language, you cannot take advantage of any of the bells and whistles that Florida offers to its seniors. And on that note, if you're going to get old and sick, arguably the best state in the country to do it is Florida, for a number of reasons, but one is we have the most liberal and relaxed asset protection laws to allow people to shelter their money and to receive assistance with paying for their senior care. Just by way of a quick example, In the last 8 years that I went back and looked at my numbers, I've sheltered over $200 million for clients that were told they had too much to receive assistance paying for care. And on a monthly basis, I shelter over $7 million a month in for existing clients of current income for those folks that are told that they make too much to get assistance with senior care. So don't ever think that you have too much or make too much. Take the time, consult with a qualified elder law attorney, and really become educated on what your options are. Doesn't mean you have to exercise those options, it just means it's a good idea to know what's available. The second document we talk about, very similar to power of attorney, is the healthcare surrogate. That healthcare surrogate document allows you to appoint folks to make healthcare decisions for you. Highly recommend that. Has some elder law language in it as well. That law changed October of 2015. So if your healthcare surrogate is older than 2015, probably could use a revision. I love the 2015 legislative changes because for the first time in Florida law, it specifically addresses things like dementia and memory care. Anybody here have a family member or a friend that has suffered from a dementia-related illness? Come on, more than one person here knows someone with dementia, right? All right. Yes. We'll pretend you do. All right. So if you've ever dealt with someone that has dementia, you'll realize that dementia is typically not a light switch. It's not that, today mom's fine and tomorrow she doesn't know any of the family members. Dementia comes in waves. There's good days and bad days, and then within the same 24-hour period, there can be good and bad times within that time. So the new law allows your agents to step in and step out to assist you in medical decisions when you're having good and bad days. Under the old law, it was a bright line in the sand. Unless one or two doctors says you have completely lost your mind and can't make any of your own decisions, your agents couldn't make any decisions for you. So it was very structured, a little too structured to allow for people to step in and step out when they're dealing with someone with a memory care issue. So I highly recommend that one gets looked at too if it's older than 2015. Third document, very simple, is the living will. That's the pull my plug or don't pull my plug document. There is not a legal answer to that, but it is a personal dignity choice. And specifically, that document comes into play if you have lost capacity to make your own decisions. The only way to keep you alive is on a machine, typically a feeding tube or ventilator, and the doctors all agree you're never getting better, stronger, and coming off of those machines. You have a choice. You can stay on the machines, perfectly legitimate, and hope that things get better, or hope they find a cure, or certainly hope for a miracle. We've seen some of those happen. Option two is, thank you, but no thank you. I don't want to be laying in this bed for months or years, not understanding what's going on, and having my family having to come visit me, and not wanting to burden them. You can certainly authorize the healthcare professionals to disconnect from their life support and allow you to pass away. Whatever you decide to do is all that matters. I have found in my career that many people don't have these conversations even with their own spouse or certainly with their children. And I have families in crisis in my office every week, fighting over do we pull the plug or not pull the plug. And I ask the question, anybody ever ask Dad what he wanted? Nope. So because many people don't have that conversation with their family members, drafting the appropriate legal documents is a really good stand-in for that. If and when that day comes, your children pick up your documents and they look, oh, here's what mom wanted. Okay, now there's not a fight amongst the family members. There's not guilt of, did I make the right move by making the call myself to unplug mom or dad? Mom or dad get to make their own decisions. And I always encourage my clients to be in control of your decisions. So those are the three big power of attorney, healthcare, surrogate, living will. On a very high level, we're going to talk about options for distribution of your assets, the traditional estate planning conversation, the time of your death to the time your beneficiaries get their stuff. Now, the gentleman that spoke earlier talked about POD and TOD accounts, and I like that. And as much as I do probates, I've done well over 1,000 probates in my career. As we sit today, I have about 67 of them concurrently running in my office. I'll be the first to tell you, probate is a sucker's game that does nothing but make lawyers money. There has never been a time where a family would choose to take the time and expense to go through probate. The only way you get into probate is that you never became educated, or you used an attorney or a law firm that didn't assist you with appropriately structuring things to avoid probate. So what is probate? Probate is a court case that we have to open up in the county in which you lived when you passed away. We have to gather all of your assets. If you had a will, we submit the will to the court. If you don't have a will, then Florida has a whole set of statutes called intestacy, or dying without a will, and it says where all your stuff goes. The downside is, minimum in Florida, 6 to 12 months on a full administration probate. During that time, your assets are locked up. You are required for a full administration probate to have a Florida attorney. So there's attorney's fees, court costs, publication fees, bond, paralegal fees, all those things that no one ever wants to write a check for. And I have never once had a family come to me after a probate and say, thank you, that was a wonderful experience. We appreciated all the time delays, we appreciated all the checks we had to write, and quite frankly, we can't wait for our next family member to die so we can go through this process again. Those words have never been spoken, and they never will. In fact, those families that have gone through probate with my firm typically are scratching at the door to come in to see me as soon as the dust settles, saying, what can you do so my kids don't have to go through what I just went through? So very important that however you do it, you structure it to avoid probate. So if you do nothing, you're most likely going to end up in probate. Now, maybe not on the first spouse to pass, because if you have everything jointly titled, then on the first spouse to pass, everything, the surviving spouse has everything. Surviving spouse passes, that's when we normally have a probate. So for all you widows and widowers that think, as tragic as it was to lose my spouse, from the legal perspective, wasn't that bad. I went to the bank with some death certificates, I got the life insurance, it was pretty okay. Well, the second spouse to pass, it will be very less than okay, because your children won't have that luxury of just handing over death certificates and settling the entire estate. So I agree that a POD or TOD designation at the bank is a good thing. It's a step. There are risks with PODs and TODs, specifically that one of those beneficiaries predeceases you. If one of those beneficiaries predeceases you, then that piece of that designation will likely now go back into your probate. So it's a Band-Aid, and as long as everybody who you list on there survives you, it can work. But there's risk. So one is one of those people pass away. The other is one of those people have their own healthcare crisis, and they're sitting in a nursing home, and now your beneficiary designation is going to go right to their nursing home. So it's nice that you thought of them, you loved them enough to leave them something, but that might turn around and go right to pay for their care that otherwise the government would have paid for. So your inheritance would have been better going somewhere else. So you can do nothing. State makes a plan for you. You can set up a simple last will and testament. Many people have a misconception that the last will and testament avoids probate. They say, oh, I only have one son. When I die, he goes to the bank, and they hand him all the money, and he goes to the county, and they give him my house. That is not correct. Your last will and testament is a roadmap through the probate process. It allows you to answer two important questions. One, who's in charge? In Florida, known as the personal representative. In other states, known as an executor. So who's in charge? And then, where's my stuff go? Is it evenly to my children? Do I have a blended family and I have stepchildren and his and hers and ours? How do you want to split that up? If you want to do any charitable giving, religious giving, philanthropic stuff, if you love the animals, you want to leave it. I get a lot of Humane Society, love the animals. Perfectly fine. Those are all great causes. We get a lot of St. Jude's Children's and Shriners. Those are really wonderful causes that if they're near and dear to your heart, you can leave something meaningful behind, but you have to spell it out. Because if you just tell your family what to do, what are the odds that Children's Hospital is going to get that check? Probably not so good. You want to put it in your documents and make sure that what you want to have happen happens. So last will and testament's good. You're in control of who's in charge, where's my stuff go. The best option, most of you probably have in this room if you have an estate plan, is a trust. More specifically, a revocable living trust. What does a living trust do? Well, I wish I could tell you it was really sexy, but it's not. It does the same thing as your will. Two important questions. Who's in charge? Where's my stuff go? But the way that it does it is dramatically different than the way that your last will and testament does it. And the chassis of the trust is specifically designed to avoid the entire probate process. And I forgot to tell you a really good part about probate for the lawyers, not for you, is that I mentioned the time frames and the minimum $4,500 in attorney's fees to get you through probate. That's if you have a small estate. For those folks that have larger estates rolling through probate, the Florida statutory attorney fee for probate is 3% of your probatable assets. So for many people who live in this area, it's not uncommon for them to die with $1 million or more in assets. If you have $1 million or more in assets that are probatable, that are rolling through the probate process, that attorney is making a $30,000 attorney fee on you, statutory. Now, I have one right now, 4.6 million, 0 trust, all rolling through probate. I'm gonna make $100,000 on that case. While I love making money, that person was not my client before they passed away, because my client would have not had to go through that process and not have to spend that money. So just keep that in mind. 3% of potentially all of your assets, although probably not everything, may be going through probate, and you may be putting some attorney's kids through private school. If that's not on your list of things to do with your money, you should seriously recommend looking at ways to avoid that process. So, the irrevocable living trust is the best option. If any of your beneficiaries have died before you, it automatically has contingencies built in. If any of your beneficiaries are minors, like grandchildren, great-grandchildren, those contingencies are all built in. If any of your beneficiaries get in a car accident and become disabled or are in a nursing home at the time of your death, contingencies are built in to not mess up the benefits that they're eligible for. So I highly encourage a conversation. If you already have an attorney, great. If you like that relationship, go back to them. If you don't have a trust, ask them why you don't have a trust. Because the answer behind the scenes might be that attorney would be more interested in giving you a will and making a whole lot more money on you when you die than giving you a trust and avoiding making money in the future. So sometimes there's a little bit of fiduciary breach, in my humble opinion, going on. You have a 90-year-old client, the attorney's in his 40s. If I was a betting man, I'm still going to be around when they die, and I just saw it last week. Actually, I saw it last week with that $4.8 million estate I just mentioned to you. The attorney up in New York said, no, all you need is a simple will. That'll get you done. Don't worry about it. Well, yeah, that'll get you done. And the attorney happened to be nominated as the personal representative of the estate. That attorney's going to make 3% on the estate assets and 3% on the personal representative's fee. So do the math on $4.8 million. It's a big, big fee. That could have all been avoided through the use of the trust.
Yeah.
So, any veterans or widows of veterans in the room? All right, so for those veterans, and thank you for your service, and the people that have supported our veterans for years, thank you for supporting a veteran. Sometimes that can be a challenge all by itself. So, 3 ways to get money from the VA as a veteran. One is a true retirement pension. You spent your 25, 30 years, you check out, just like if you're a police officer, firefighter, school teacher, you can have a pension. Super simple, never need a lawyer for that. Option 2, you can have a service-connected disability, which means you were injured or exposed to certain chemical agents during your service. That is now having an effect on your health, and you go through the rating process, and the VA may qualify you as a disabled veteran, and then also, depending on your rating, might write you a check every month. The problem with service-connected disability is quite often for our seniors, they're dealing with things like dementia, hearing loss, bad hip. Those things in 2019 are very difficult to directly link to what happened to you in 1945 while you were serving in the military, or even 50 to 55 in Korea. We're going back 60, 70 years trying to figure out, is your bad hip today just because you're old and you got a bad hip? Or was that attributable to your service? The VA loves to use that length of time to say, well, you can't connect the dots, so sorry about your hip, or sorry about your hearing, or sorry about your dementia, but you can't prove that that was service-connected. So people have a heck of a time, they get super frustrated, fighting with the VA year after year on trying to get those benefits. We can help those folks try to accelerate that. But there's a third benefit that I love to work on. It's known as a non-service connected disability. So as the name implies, there's something wrong with you today that you need either in-home care, assisted living, or memory care, but it doesn't necessarily have anything to do with when you were in the military. Many people refer to it as aid and attendance. Has anybody here heard of aid and attendance? Only the folks that should know about it, right? All right, so that sheds light on it. So we have several veterans and several widows, and no one in this audience has heard of it. Let me tell you why. Because the VA doesn't really like writing checks, and they will try not to at all costs, including they don't advertise this benefit. It's never in the VA magazine. If you go down to the VA and you ask them questions, the social worker and the local VSOs who work for the county are not trained on this benefit, And it's, like any good government worker, it's easier to get you off the phone or away from their desk than actually do work. Because those folks don't get paid on efficiency. Those folks get paid to warm a chair and breathe the air inside their office. So it's easier for them to say, oh, you make too much money, you have too much money, you don't qualify, you didn't serve long enough. They really don't understand the benefit. So I am VA accredited. I've been doing this for over 10 years on the VA side. And recently the VA proper has recognized my ability in this area. And both James Haley in Tampa and Bay Pines VA Hospital in St. Petersburg have invited me to come in and train their employees on their own VA benefits. While that's an honor, it's also kind of frightening. They don't know their own benefits. Specifically at James Haley, I met with 4 geriatric care doctors. Now these are doctors specifically that deal with old veterans who are sick, kind of by definition. 3 of the 4 doctors didn't understand this benefit. One of them argued with me about the qualifications until I took out the rule book. So now the VA sends me clients directly. I appreciate the referrals, but I wish the VA would get their act together and help our veterans and widows on their own. So what is the benefit? How do we qualify for it? So the benefit is a cash, tax-free, direct deposit payment, just like your pension or your Social Security, right into your bank account to help you offset the cost of in-home health care, assisted living, memory care, and now, Tammy, we may have talked about this, post-October 18th of 2018 with the new rule changes, we can get aid and attendance for independent living. We have a couple of hoops we have to jump through, but the answer is we can do it, and I've already done several of them. All right, so how much does it pay? Well, for a married veteran, it will pay $2,230 a month, about $26,000 a year. For a single non-married veteran, $1,881 per month, or about $20,000 to $21,000 a year. And for a widow of a veteran, $1,209 a month, which is about $14,500 a year. And remember, tax-free, that's always nice, and direct deposit right into your bank account to allow you to spit it out the other side and pay for your care. Now, what are the qualifications? It is called a non-service connected disability pension. So many people have the misconception, if I didn't spend 20 or 30 years in, I mean, think about it, when else do you get a pension? You gotta put a long time in to get a pension. Well, this pension is only called a pension. All that we need is 90 days of consecutive active duty service, 3 months. Certainly wouldn't, in most people's mind, think about pension. 90 days consecutive active duty. 1 day had to be within a recognized war period, but you did not have to be in the war zone. Just got a guy qualified yesterday. He was the cook. Nobody shot at him. He wasn't even in the war zone. During Korea, I think he was in the Philippines or something. So he wasn't even near the action. But as long as you were active duty at least 1 day during one of those war periods, then we're good. Tell people you could have been clergy, or you could have been in the marching band for all I care. As long as you were active duty, we're good. So 90 days active, 1 day during a war period. And the other one's pretty simple, better than dishonorable discharge. So general, medical, honorable, into hostilities, as long as it's not a dishonorable or less than honorable, we can make that work. So the other one is over 65, which most of my clients put that behind them a few years ago. So over 65, and that's all we need for the veteran. So relatively simple, but more people should know about it. If we have a surviving spouse, we have to ask a few more questions. Was the spouse married to the veteran for at least 1 year before the veteran died? So they don't want people on their deathbed getting married and trying to hand off benefits. I'm not sure how often that happens, but apparently it was a thing. So more than 1 year before the veteran died. They had to be married to the veteran at the veteran's death, so typically a divorce would take away that benefit. And they cannot have remarried after the veteran died unless they remarried another qualifying veteran who also died. So that happens. Sometimes, depending on your age, you can't throw a rock without hitting a veteran. So if you get remarried, it very well might be to another veteran. But we'll look at that. Really simple. All I need is a copy of the discharge paper, typically known as a DD-214 or notice of separation. There was a big fire back in the late 60s that burned up a bunch of records. If that happened to you, there was actually 16 million service records that were involved in that incident with no backup copies. We can get copies from the National Archive to kind of recreate the service record. So if you know that your documents were burned up, we can work around that. So We know what it takes to become a qualified veteran or widow, and we know what the service requirement is. So what we're looking for at that point is, do you need help with activities of daily living? Bathing, dressing, toileting, medication management, meal preparation, housekeeping. And it doesn't have to be number 10. It can be number 1 on the dial. So for instance, you ask a veteran, do you need help with bathing? Well, if he has the ability, he'll probably punch you in the face. Because he doesn't need help with anything, because that's how they were wired. But he's thinking, someone's in my tub doing the scrubbing, and I don't need that and I don't want that. But assistants can actually be someone standing outside of the bathroom in case you need them. Assistants can be someone throwing the towel over the shower curtain for you. Assistants can be a pull cord or a pendant that if you need something, you press the button, the cavalry comes in to get you. Those are all assistants. So don't have the misconception that assistance means number 10 on the dial. It can mean number 1. And Tammy's really good at knowing how to work that. So you need assistance.
Sorry. Guys, I know we're running a little bit long. You guys want him to finish?
Yeah.
There you go.
Why, thank you. All right. I will make it quick. I don't want anybody to get a blood clot and blame it on me. So, all right. So what we need is 2 or more activities of daily living signed off on by the doctor. That always works because I fill out the doctor form. The next thing we're looking at, there's 2 financial tests. On a high level, it doesn't matter how much you make, it matters how much you spend. And that's where a lot of people that go to the VA get misguided. I had a client lived in the Tampa area. They had $2.3 million in assets. Husband and wife made $9,000 a month in retirement income, which is a really great retirement income. Both of them needed 24/7 care. They elected to have that at home. So the guy went down to the VA and said, I've heard about this benefit, can you get it for me? And they said, how much do you make every month? And he said, well, we make $9,000 a month. They laughed him right out of the VA office and said, get out of here, you make too much money. Well, that's only the first part of the inquiry. What they didn't ask is how much are you spending on care? Because this particular husband and wife had 2 people 24/7 in their home, and they were spending upwards of $20,000 a month for private duty 24/7 care. So making $9,000 is a lot of money, but if you're spending more than the $9,000, now the VA should be asking more questions. So remember, it's not what you make, it's what you spend, and if you've ever looked at good quality senior living, certainly memory care and assisted living, it ain't cheap. And so for a lot of folks, over 90%, when you get into assisted living or certainly memory care, you probably will be writing a check for more than what you make. And that's when we start dipping into the nest egg. So there is no income cap, but just know that there is an analysis, and you want to talk to somebody that really understands. Then there is the assets. Under the old pre-2018 rules, I could take millions and millions, dump it into an asset protection trust, the next day apply for benefits, and the VA couldn't deny me. Well, they didn't like us doing that too much. So in October of last year, they changed the rules. There's now a 3-year look-back period on asset transfers into trusts. So on a very high level, if you are a veteran or a widow, and even if you don't need this benefit right now, if you think you might want it or need it in the future, it is imperative that you set a consultation with a VA-accredited elder law attorney sooner than later, because you might have to engage the legal strategy and then sit on it for 36 months and then apply. That maybe how we have to do it under the new rules. There's a lot of ways to get around it, but you want to get information sooner than later. And all of our consultations are always no charge. For folks that are far away from our office, we typically will do a phone call, we can do a video conference. If I am in the area, I'm always happy to meet with a family at no charge and just talk about what your situation is, what benefits might be available, what legal strategies you may want to look at, and certainly review all of your documents to let you know whether they are, in my humble opinion, good quality elder law documents. What I can tell you, generally speaking, is if you have not had your documents drafted by an elder law attorney, probably great for estate planning, not so good when you get old and sick. And all of us are getting older, and the majority of us are not getting healthier. We're just hoping to tread water at some point. And so if the day comes that we get sicker, we're going to want those really good quality documents in place. The last thing I'll leave you with is just, listen, we all know that bad things happen to good people sometimes. So if you have friends or family members who might be going into skilled nursing, and the families are shocked when they get a $9,000 to $16,000 a month bill for that skilled nursing home, even if they have the money to pay it, I highly recommend that they consult with an elder law attorney, because you might be able to get the same care in the same facility in that nursing home and pay less than 1/10 of what the retail price is to get the same amount of care. Certainly we have husbands and wives, we can work magic, and we can take all of the income, we can move it to the spouse, we can artificially impoverish the person who's in there. You don't have to get divorced, you may have heard that story, we don't have to do that, but we can get benefits that otherwise you just write a check for in perpetuity. We can lower that amount. Yes, sir?
Just a quick question, in a scenario where you have a veteran and the spouse that are both living, the veteran doesn't need help at this time, and the spouse is eligible for aid.
All right, so the answer is, if the veteran is still alive, and the veteran is out playing golf every day and super healthy, and the spouse has dementia or needs home care, can we do that? The answer is yes, at a reduced rate. So, as long as the veteran is alive, the VA really wants to focus on the veteran's needs. I get that. But there's 3 levels of benefit for aid attendance. Aid attendance is the highest, then there's something called housebound, and then there's something called basic pension. So if the spouse is the one that needs the care and all the other facts line up for us, then we can get, it's $1,744 as opposed to the $2,230. So you get less, but the answer is yes, you can qualify if the spouse needs the care, it's just at a lower payout than if the veteran needs the care. Yes, sir?
What if the husband dies, who was the veteran, is the wife still qualified?
Absolutely, as long as the wife was married to the veteran for at least 1 year before the veteran died, was married at the veteran's death, and has not remarried since the veteran's death, then absolutely. I do get some widows that come and say, well, I've never looked into this benefit because we weren't married while he was in the service. That is not the inquiry. You could have married way after he or she was in the service, and as long as married for 1 year before the death, at the death, and not remarried, 100% we can give that person benefits. Good question. Any other quick questions? I know everyone wants to stretch. Yes, sir?
Consumer payments, will the benefits be cut?
If the surviving spouse remarries, yes. If the remarriage will cut off the benefit unless they remarry another veteran, and then we gotta run all the numbers again. And then depending on if that second marriage they're alive or have passed away, we can look at that. So I'm gonna have to dip out a little bit. Yes, sir?
Real quick, on living trust, how often should you use it?
So here's the thing, living trusts are pretty hardy. They really only need to be reviewed as a practical matter if who you want to be in charge has changed, or if any of your beneficiaries have changed, or if any of your assets have really changed. We recommend our clients come in every couple of years just to find out what's going on with them and their family situations. So I would say, to be safe, best practice is every 2 to 3 years, but really no work needs to be done unless one of those major things have changed in their lives. Well, I appreciate the opportunity. If anybody does want a consultation at no charge with myself or any of my staff, Sandy over here can take your information. We will call you to set up a consultation. Again, absolutely no charge, and I love just talking to people and figuring out if there's a way to put them in a better place than when I met them. And certainly for our veterans, if you're too young and too healthy for this benefit, I'm going to be happy to tell you that, but then I will also tell you what are the triggers that if you become less healthy, when can we start the benefit? Because we can never go back in time and get lost benefits